we're definitely going to talk about that certificate of trust when we get there. And if you don't know what I'm talking about, you'll know when we're done. Well, now I'm trying to make it go.
It'll go after, yeah, hit that one.
This one?
Yeah.
Ha ha!
And then that'll work.
Oh, love technology. I actually do, and it's great when it works. So as you guys may know, when we talk about estate planning, that really is a broad term that encompasses things, tools, documents that we should be able to use now while we're living, and also then, of course, documents when we have passed. So the estate plan really looks at creating kind of our current wishes and our future wishes, particularly related to the assets that we accumulate as we go along. Now, because this is actually a legal Con Ed session for you all, estate planning comes from the laws, the rules, come from the Estates and Protected Individuals Code. So you may see EPIC, EPIC. That's what all of these laws, rules, statutes, and processes are under. So MCL, you see I have that on there. That means Michigan compiled laws. And then it's 700, 500, 400, but estate planning is under the 700 chapter of our statute in Michigan. So, well, really, is estate planning simply for those folks that basically have a high net worth? Is that true? Oh, I see head shaking. See, I had to be fancy. That's my one fancy PowerPoint. Falls right in. So a lot of people will say, well, I don't really have a lot. I don't have a lot of money. You know, why do I really need to do an estate plan? And really in the big picture, as you guys may have experienced in your life or seen other family and friends, it's really not the money that causes the biggest issues. It's really those sentimental things that are important to families. So it's very applicable, even if you have just a basic will and a list of your specific gifts to your family. Because in my family, it is my grandmother's potholders. So she passed away many years ago, but she was 98, and she sewed potholders on a Singer treadle machine, you know, with your feet. And so she would quilt it and make potholders, using your kitchen. That is the prized possession in our family. So we all have bags of them and we want to pass them down to our kids and our grandkids. So doesn't mean that you got to have a lot of money, but families, I know, they all have sentimental things that they want to keep in their family. And estate planning can help you with that. Now, why should you do an estate plan? There's a few things up here, that talk about, can't see the top one, but that's all right. Peace of mind for a lot of folks. Some people really want to try their best to have things set up so their kids or brothers and sisters, that they're trying to avoid conflict. Now, as we know, no matter what we do, if people are going to have conflict, they're going to have conflict. But by setting up your wishes in a roadmap that shows what your wishes and plans are, and if you feel comfortable enough talking to your family about it, hopefully they'll get everybody on, going in the right direction. So it's unfortunate, even in the time that I've been practicing estate planning, family relationships sometimes not only get fractured, but absolutely get cut over some of these issues, because It's just what happens. Again, it's not really about the money. It's really about some of those sentimental things that create issues. So, is there anything else that you guys would think why you would make an estate plan other than what you're seeing on the screen? Probate avoidance, I see. Anybody else have any other reason why they want to do an estate plan?
That planning is done for when you are live or like, right?
Yes, so doing, drafting, executing an estate plan has to be done when we're alive. And then I'll get a little bit into those tools that you would use to do that. But some of the documents in an estate plan work for us now while we're living, or if we become incapacitated, and then some of the other documents are there for when we've passed away. Well. Yeah.
Yeah, just, there you go. No,
Can
hit
I-
the enter.
Can I hit it in? No? Can I do that? It's testing me today.
There we go.
Oh,
Now again, it should.
so now I'm wondering. Haha. Thank you guys for hanging with me. So one of the things that's really important is when a person or people are considering doing an estate plan, the attorney really must know and be very clear on who the client is. Because as you may guess, many times we get calls from adult children because they think or they want or they say their parent said, you know, my mom wants a will, or my dad wants to do a ladybird deed. And that's super. But as an attorney, I need to talk to the client. And as you may also guess, as an estate planning attorney, I also have a duty, ethical duty, to make sure my client is competent if I'm going to be drafting and executing documents with them. Because even well-intentioned adult children are still not the boss of their parents. Now, unless it's in a position where that child has gotten a guardianship and conservatorship over their adult parent through the court, we as adults are presumed we're able to make our own decisions, even if our kids don't like it. Just as they were young and they did things we didn't like, as we get older, seems like the tables turn, but it is still up to that individual to create an estate plan to what they want, not necessarily what their family's trying to push them toward. Now, doing an estate plan, I get lots of folks that say, well, you know, I should have done this years ago. Well, there's a lot of shouldas that we shoulda do in our, life. So when you do an estate plan, it's the perfectly right time for you to do it. Some people come to me and they have, children that are in their 40s. And of course, some people, I talked to a woman yesterday, she has a 6-month-old and a 4-year-old. Whatever our age and stage and purpose in life, that is exactly the right time for you to do your estate plan. Now, these are the estate planning tools generally that I use when preparing an estate plan for a client. So we have a will. You'll have a power of attorney for financial matters. You'll have a patient advocate designation for your healthcare decisions. Some people will call that a medical power of attorney. I also like to provide the HIPAA privacy waiver because I'm sure we all know we can't get medical records of our adult children, our spouses, without their permission. So also, I prepare a certificate of trust. That's the document that's a very shortened, like 2-page summary of your trust, if you choose to have a trust drafted. And then it'll have some additions, like if you own real property, it'll have that legal description. And it will also have the powers of your trustee. So that certificate of trust is what you take around to the world and say, look, bank, here, life insurance company, I have a trust. And it's evidenced by that shortened document. Because many times people do a trust because they want it to be private. They don't want it filed anywhere. They don't want anybody knowing who they gave what to and when and why and how. I also like to add what we call a personal property affidavit. That takes care of all your tangible personal property. Then, of course, with real property, as you guys know, you've got to utilize a deed to say what you want to happen to that property. And if you're going to use that deed to put that property under your trust umbrella. And finally, I do provide funding instructions. Because once an estate plan is drafted, my goal is that then you can all go forward and manage your estate plan to how it works for you and how you want to have your assets go to your loved ones when you're no longer here.
Are you going to expand on the Ladybird?
I'm getting, yeah.
Cool.
So this is the brief overview. So boom, we're going to start talking about each of these documents. So when somebody does a will, as you guys may know, and that person passes, it's called testate. They pass testate, meaning they had a will. If you pass without a will that you've drafted yourself, you are considered passing away intestate. But as I tell people, if you don't make a will, the state of Michigan's already made one for you. You might not like how it goes. Maybe best to do your own. And so these are under, as you can see, the MCL, chapter 700, and it'll give you, that is the number to the statute. These are the requirements, basically in Michigan, that have to be there for people to make a will. So again, it's generally, yes, you need to have capacity. You need to understand that you're making a will. You need to know what assets that are yours and who you're going to give them to, and understanding that by doing this document, it's going to go to these people when you pass. Now, just an aside, Michigan also does recognize holographic wills. So again, these are the general overarching rules of making a will. It needs to be witnessed by two, the best practice is disinterested witnesses. So like, don't have a beneficiary in the will, like sign to witness it. It's not against the law. I just think it's best practice to avoid any problems. A will can also be notarized in Michigan. So two witnesses, a notary. I use two witnesses and a notary just to wrap it all up 100%. But that holographic will, actually, I have a couple cases right now that we're trying to admit an holographic will to the court. Under that statute, all it says is you have to basically write in your own handwriting kind of what you want to happen, who you want to get what. Yeah, you can do it on a napkin, believe it or not. Sign it and date it. Doesn't need to be witnessed. Now, is somebody going to challenge that? Depends on your family. The bigger thing, if you're going to be doing something in that way, is to be talking with someone, letting someone know that's what you're doing. But of course, I don't recommend that you rely on that for your estate plan. But I do have a case right now, like I said, where this gentleman wrote out his wishes and who he wanted to get what, and he told them he left $12,000 in his dresser drawer. I mean, it was very interesting. I haven't had the court validate that that's a will yet, but we're waiting for that court hearing. Now, the next piece.
Sorry,
Go ahead.
suppose you don't have a will, right? You died without will, right? Then how the Michigan state try to distribute
Your property.
right?
So, as I mentioned, if you don't make a will, the state of Michigan has already made one. And under their intestate law, the way your property would go is first to spouse. But if you don't have a will, your spouse does not get everything. So the spouse will get the first 150,000 or the first 100,000 of your estate plus half. But again, if you don't have a will, your spouse does not get everything. That was probably the most shocking thing I discovered when I started practicing this law. So if there's a spouse, they'll get their share. Then it goes to children. If there's no children, it goes to parents. If there's no parents, then it goes to your siblings. Then if there's no siblings, it goes to grandparents. And then believe it or not, I have a couple cases where that has all been exhausted. So we have to go back up and go to descendants of grandparents. So then we start talking about cousins. And so yes, literally we have charts of figuring out who's in what position to inherit. Just best practice, just do a basic will. But it'll get distributed, might not be how you want it to.
Oh,
So the next piece is a durable power of attorney for financial matters. Now, you guys may know that last year on July 1, Michigan has a brand new Uniform Power of Attorney Act. They threw out all our old law and put in this new law. And my understanding is that because I know this, I've had clients have issues with financial institutions accepting the legally drafted power of attorney under Michigan law. And usually it's the big banks, PNC, America, the Third. Well, that's not our form, or that's, that's Michigan law. You guys are here. So apparently some financial folks and attorneys got together and said, look, we got to solve this because you need to recognize the legal documents that we're drafting. So there is actually a statutory power of attorney. There's a specific form actually listed in the statute. And again, this was July 1. So we're like, all right, let's wait and see how this is going to work. And believe it or not, before the end of last year, yep, there was already a lawsuit against, I can't remember the bank, because they weren't accepting it. So ultimately we make laws and sometimes we have to go to court to enforce those laws. But having a durable power of attorney is one that I think is a really important piece that hopefully will avoid the need for a guardian or conservator if we lose our capacity. Because getting guardianship and conservatorship over an adult should be the very last resort if there's no other options. It's expensive. There's a lot of reporting to the court that goes with it. And in general, in Michigan, we're really a state where we want to have us adults be as independent as possible for as long as possible. So having a power of attorney for financial matters, if I become incapacitated, my husband, my son can simply step into my shoes and manage my financial business. The next piece in an estate plan would be a patient advocate designation. So some of you may know that Michigan and Massachusetts are two states that use what we call a patient advocate. So we don't use a living will or a check a box, and this is what I want to happen with me medically. We designate a person. So this person will speak for us. So let's say I go into the hospital to have shoulder surgery, but I don't wake up from anesthetic. Now, I filled out all those documents, and you've probably, when you've been in the hospital, fill out a medical directive. You filled out, do you not want to be resuscitated? If you look closely at those documents, you'll see that it does say patient advocate, and you are designating someone to speak for you if you can't make your own medical decisions. So if I'm not waking up from anesthetic, the medical people are going to go to my husband and say, oh, what do you want us to do? And he knows what my wishes are because we've discussed them. Now, this also could be a situation where, let's say I'm in a car accident. Well, they're gonna rush me to the hospital. They're gonna try their best to keep me alive and stabilize me. By the time my husband gets involved in this, it may be the circumstance where I don't have any brain function, but I have artificial things keeping me alive. He would have to come in and say, if there's no brain function, you need to remove the breathing, artificial breathing, you need to remove the feeding tube. So these decisions are tough. I mean, we can kind of talk about it now, but when it comes down to it, they're pretty tough. So when you designate a patient advocate or a backup, really know that that's the person that you want and talk to them about what you want or don't want. Now, the other beautiful thing that I like about this, one of my favorite things when I talk about it, in Michigan, our ability to have this patient advocate allows us to change our mind. I could tell my husband something today, next week I could change my mind, and if I'm on my deathbed, I could say, no, I don't want any other life-saving things, you know, it's time for me to go, and he is bound to follow my wishes as he knows them. So I am curious, I still haven't found the answer about how other states that use, you know, a check a box or a living will, there's too many circumstances to go, well, maybe I want feeding tube because I need to recover, or, but anyway, that's my curiosity. Someday I'll figure that out. Did I just go past something? Nope. So as I had mentioned, the certificate of trust, that's that shortened document. And I'm sure many of you may have already dealt with a certificate of trust when you're on the buyer or seller side of a transaction. So if somebody does have their property titled to the trust, in order for that transaction to take place, that title company is going to want generally a current certificate of trust. I've heard current means dated less than a year old, sometimes dated less than 6 months old. So if people do have a trust, that is something that needs to be managed throughout their lifetime. And so generally, you know, if you have a certificate of trust drafted when you sign all your documents, you know, it could be 5 years, 10 years, 15 years down the road before, say, you want to sell your property. So what I've been doing and what I see many more estate planning attorneys do is they're utilizing, and I utilize a ladybird deed, where I have the people, the clients, deed their property to themselves for their life, and they have complete control of that property. So they can sell it, they can tear it down, they can add to it, no problem. And then the trust is listed as the beneficiary. So that way, if they pass, then it goes into the trust and flows through the trust. Part of that is I find it more cost effective and efficient for clients to not have their property actually titled to or owned by a trust. Because that way, again, I can sell it. But if I have a deed that says, my husband's name is Bruce. So if we have Wanda and Bruce deed the property to Wanda and Bruce as trustees of their trust, that means the trust owns it. That means there has to be a certificate of trust at any transaction with the real estate. Now, currently, I think I'm charging about $600 to do a certificate of trust.
So when you have a certificate of trust and the property is in the trust, does it have to be registered and recorded in the county that the property is in?
No. So in Michigan, we have no requirement to register or record the trust. But if I'm maybe understanding, if a transaction happens with property that's titled to a trust, that certificate of trust gets recorded when the deed gets recorded. I think that's maybe what you're asking.
Right, so, but if you were working with clients, didn't ask the question, if the property was in a trust, there's no way for title to ask for that if it's never been recorded.
Well, so I guess backing up to the big picture, anytime I work with clients to draft any kind of deed, record it, record it, record it. Please don't keep it in your home. Please don't put it in a drawer. Put it into our system. So again, we know what's going on. But yes, I mean, anytime a deed is not recorded, it creates problems in the chain of title. Oh, you good for now?
Yeah,
Okay.
Did I hear correctly that the certificate of trust can expire?
Yes.
6 months to a year?
Yes.
It's only good for 6 months to a year, then it needs to be renewed.
So the question is really, does a certificate of trust expire? The actual answer is no, but the world out there, like a title company or a bank, is going to say, well, this certificate of trust is 5 years old. How do I know the trust is even valid? How do I know? Says my battery's running low, Darwin. How do I even know that this even exists anymore? So it's really not about the document expiring. It's about when you go to use it in the world. If you go to open a bank account and you want to title it to the trust, the bank might go, well, this certificate was signed 5 years ago. We need to know that this is current. So same as when there's a transaction with real estate, the title company will tell you, oh, it's signed 2 years ago, that works for us. Or the title company might say, we need it dated less than 6 months ago. Even, so it depends on that title company.
even if it was recorded.
So, so when a deed is drafted to a trust, that deed simply gets recorded. A certificate of trust does not get recorded with that. Even if it is recorded, it's still old. So the new transaction, the new title company, the new buyer has no idea if this trust is even still valid. That's why when you guys are dealing with property that's titled to a trust, basically it's going to say to Jim and Susie, trustees of the trust, you're going to need to have a certificate of trust to complete that transaction. But the title company is going to give you direction. Do they accept what they currently have? Do they need a new one? Now, the trick with this is many times I can draft as an attorney an updated certificate of trust. But it depends on what the terms of the trust say. Because I've run across 2 of them last year where the trust terms said only the successor trustees can sign a certificate of trust, not an attorney. Most of the time, I, as an attorney, can say, I've reviewed the trust, it's not revoked, here are the trustees, and the title companies are perfectly happy. But that's why it costs quite a bit to have a new certificate of trust or an updated one drafted. Because I have to read through all the terms of the trust as well as any amendments, because I have to follow those terms.
Did you even put your house in a trust then?
I think from what I could guess, back in the day, that's sort of just what people did. I mean, there are other things that happen when you title your real property to a trust. You also have to notify your home insurance or your insurance company that there's an additional insured. Again,
About
like,
your liability to protect
yeah.
from insurance.
But it depends on that client, because if they're like, well, I'm only gonna be in the house 5 years or 10 years, I would just, do a ladybird deed, because again, you're gonna run up against, not that it's a big hurdle, but it takes time and money to move property if it's titled to a trust.
Right, because from what you're saying, the certificate of trust is only good for, let's say, 6 months. So if I was to put any property in a certificate of trust, I would essentially be paying $1,000 a year to have it updated.
Yeah, so the world, like I said, it's the title company that you're working with, or the bank you're dealing with, or the financial institution will tell you, I'll take that certificate of trust, or I need a new one. And we just don't know if they're gonna require 6 months, 1 year. More common for a year. I did run across a title company that wanted it dated less than 6 months old. But that's their rules.
Wanda, is there a difference between a trust and a certificate of trust?
Yes. The trust is the document that controls all of your wishes regarding all of your assets. All of the conditions that you put in there for any beneficiary, like, you have to finish your bachelor's degree before you get any money, or I've had somewhere you have to be married to have this money. The certificate of trust is that little teeny shorthand from your trust. Generally, it's only 2 pages. Again, it just says the name of the trust, the date that it was drafted, any changes you've made, who are the successor trustees or the current trustees. It's not revocable, or it's not revoked, or if it is, because most people do a revocable living trust, who has the power to do that? So it's a very shorthand, just need to know basis that you provide to a title company or to a bank. They don't need, they shouldn't be asking for your entire trust, because it's not their business what's in it. So it's a short snapshot, a small picture of your trust.
Well, you're not saying that you have to renew that certificate of trust.
No,
You have the trust, and just when you go to sell your house, you have to get one.
if,
So it's not something that you do every year.
right,
I thought that's.
yeah, very good point. So the certificate of trust, again, I tell people, you go about and use it. You just use it. You're gonna run across somebody that's gonna say, sorry, it's too old. You gotta get a new one. Then that's when you have to go to an attorney to get it updated. But it's the world out there that drives that. So I'm just, just use it until somebody tells you you can't. That makes sense for all of you guys with a certificate of trust?
What about to Galvin's point about increasing your insurance on the liability end of things? Would having a trust involving your property have any effect on an individual that might be named on the certificate of trust?
Okay, so the question is sort of around liability. And let me see if I can put this into an answer. So when you have a revocable living trust, and anybody that you're naming in there to receive things, receive money, receive property, receive personal items, that gift is future. So there's nothing currently that those beneficiaries have no control over your assets. They're yours. So if there are problems or issues with creditors of those beneficiaries, the creditors can't scoop into your trust. It's your stuff.
Okay, and that same.
Yeah, no.
Well,
And so as far as in terms of the liability, I'm not an insurance person. I can't answer that. I would definitely, you have to talk to your insurance company, whoever you have your, homeowners through, to find out what it means if your property's titled to the trust, or if, you know, it's just you as the individual person.
One other question. To you, bro. Why would that property being held in a certificate of certificate of trust have any effect on your insurance payment?
The way I understand it is that it's in a vault. So it's not for, say you were in a horrible car accident, loss of life,
Oh,
can't go after
oh.
anything that's held in the trust.
Ah, so that is absolutely,
That would be your risk of liability.
Yeah,
If
so-
you're at fault and another driver.
yeah, so let's be clear. Let's be clear, that is absolutely not true. Absolutely not true. If you have a revocable living trust, any of your creditors or any liability you have, they can scoop in.
They can't.
They can. It's your money. It's absolutely transparent to you. The trust is you, you're the trust, it's yours. Now, if you have an irrevocable trust or some other types of trusts, particularly an irrevocable trust, you give up your control of your assets. So your creditors can't go in and get it because it's not your money anymore. So that is one thing, and then thank you for asking that, because many people think if they do a revocable living trust, their assets are protected. No, they're all yours.
Tell me more.
So
That's how my attorney set it up.
yeah, so an irrevocable trust is where you do not have control of your assets. You designated someone to be the trustee. Now, many times people will do that if they're doing Medicaid planning. In my personal instance, my mother-in-law was diagnosed with dementia. So she chose to do a irrevocable trust. Not that she was doing Medicaid planning. She had too much money to qualify for Medicaid at any point. She wanted to protect herself from others out there. She didn't want to get a call, say, hey, what's your social security number? And, you know, what's your bank account number? Because she was losing her capacity. So she created an irrevocable trust, put her two sons as the managers. So then no creditors, no predators could come and take her money. So again, there's different tools. Generally, what we're talking about today are these sort of basic tools that folks use. Many folks don't want to give up control of their assets. Certainly, maybe not at this point.
All right, I've got a couple questions here if you want to address these. Does the property after death need to be recorded in the name of the trust after the death of the owner? In this case, her father.
So, guys, let me just say, at the end of this presentation, and I'll tell you the email right now, it's estates with an S, ESTATES at Linnell, LINNELL firm, FIRM.com. If you have particular questions that I might need more information about to give you proper advice, just send me an email. Of course, it is my joke that, you know, if you send me too many emails, I'm going to send you a bill. I haven't done that yet. But just with that question, again, I'm not really quite sure, because if you have a ladybird deed and it's going to then go to the trust, that trustee would then handle it. So you may need to email me.
Trust in existence, there's just too many variables.
Yeah, I might need more information.
Okay, here's another one. Let's see if we can do this one. I have a client, house is only in her name. She has a son, but not on the house. Should she put him on before death or get a ladybird deed?
Ladybird deed. So one of the things we have in Michigan, and 4 other states use this as well, is that ladybird deed. So it's a very cost-effective and efficient way to keep your real property out of having to be probated. So you simply deed that house to yourself for your life and you have control. Then when you pass, whoever you listed as the beneficiary, be it your son, your 3 kids, your sister, whomever, the minute you pass, they automatically own it. Bam. It's not probate, there's no issues. If that works for your situation, then definitely do a ladybird.
Now, here's a question for me following up on that. Is a ladybird deed, what is the legal term that we've learned in pre-license training?
So legally, it's called an enhanced life estate deed. So under property law, there are things called life estates. But the beauty of the enhancement means usually when someone is deeded or given a life estate, they can use that property for their life. They can't sell it. They can't do anything else with it. They can use it, they can live in it. But with an enhanced life estate deed, they control it as well. So that's why, the property owner, say it's my house, me and my husband deed it to ourselves for our lives. Once both of us have passed away, we're gonna list the kids there and they're gonna automatically own it. So then those owners are gonna have to do whatever they're gonna do with it. Is one child gonna buy the other out and live in it? Are they gonna sell it and split the money? It's up to them.
So then, here's a good time, guys, for us to know, we're not attorneys. Know enough to be dangerous and smart enough to say, I know that you need to consult an attorney. Don't give legal advice. So that's not what today is about. Today is enough to educate you to go, I'm not an attorney, but I know somebody.
Fair enough. Yeah, you don't want to be caught practicing law without a license.
Question. Does the ladybird deed eliminate any exposure to state assets? For instance, I'm still living, I have a ladybird deed, my kids are named as beneficiary. What happens if for whatever reason I have to put into a nursing home? The state would normally have access to whatever you have.
So, good question about doing or having a ladybird deed and then a lot of times discussion is around Medicaid planning or what access does the state of Michigan have to get at that property to help pay for your care if the state of Michigan is paying for your care. First thing I will tell you is I do not do Medicaid planning. Just as Darwin says, I know about this much, enough to be dangerous, but I am not a Medicaid planner.
Okay, so kind of on the fact that he's sitting on Medicaid, not Medicare. Where the
Correct,
state has-
correct. Medicare does not come after your property. So I would have to refer you to a few people that I know, and there really is a handful of people in Michigan, attorneys in Michigan that are real experts at Medicaid planning.
So one other question. Does that ladybird deed protect the beneficiaries from any possible liability exposure? For instance, if someone wanted to sue me, would the house be off limits because,
No,
no?
no. So having a ladybird deed titled to yourself for your life, it's yours. Your creditors can come and take it. Get sued, they can come and take it. Having beneficiaries on that is irrelevant.
No other family members, that are actually.
Beneficiaries.
So the beneficiaries that are named on a ladybird deed are the same as beneficiaries that you put on your bank account. They do not have that asset. They don't own it. They have no right to it until you're gone.
But if they're named on the deed.
If they're actually titled,
Ladybird.
if it's
Title.
yeah, if it's titled to, mom, dad, daughter, son, and you're all on there, yeah, then you're all open. You're all owners, you own part of it. And we'll get to that type of property ownership, but
You might get one quick question here to answer cost of a ladybird deed.
we just kind of adjusted our prices starting in January, so I want to say it's $450 for a ladybird deed. And we do generally get it tax certified, which is required, and recorded. Because we want deeds recorded.
Yes.
I don't like bird.
How a ladybird deed got its name is up for debate. So many people will say, you know, it's President Johnson and Lady Bird, his wife, they used this. It was used before their time. So that's what I've read about this rumor of why we call it that. So there is no real consensus. So this revocable living trust, just to kind of remind you guys, I use an umbrella to describe having a trust. So if you're going to create a trust and draft the document, you're creating this umbrella, and then you're going to have to take some action to put whatever assets you want under that umbrella. It does not happen automatically. So if you draft a trust in an attorney's office and you walk out the door and you don't do anything, you do not have a trust. You have a document you paid a bunch of money for. Just a quick about this personal property affidavit. I want to make sure when people do an estate plan that there's nothing left out there hanging out undone, not addressed. So doing a personal property affidavit takes all of your personal property. It's just a simple one-page sworn statement. And you put your shoes, your clothes, your jewelry, your art, your snowblower, your furniture, whatever you have, that's tangible personal property, also under that trust umbrella, if that's what you want to do. Now, we've been talking about deeds. And so just a reminder for folks, when we discuss deeds, of course, mostly what I deal with are ladybird deeds because it has that element of estate planning in it. But of course, the other real estate attorneys at my office do a lot of warranty deeds or quit claim deeds. So I'm going to get on my little soapbox a little bit about quit claim deeds. They do have a place, but they are not the live all end all. And I've seen too many people drafting, executing, and filing quit claim deeds that creates all kinds of problems for family down the road because either the deed shouldn't have been signed. I had a client who had grandchildren of someone signing a deed and recording the deed. None of it is valid. They have no right, you know, to sign off grandpa's interest. That's what probate is for, but we're not going to talk about probate today. So a quit claim deed definitely is a tool and has its place. But if I'm buying property, I want a warranty deed. I want to know that it's mine and nobody else is going to come in and start claiming on it or have a claim to it. Does that make sense? Now, just sort of quickly, I'm not sure where we are time-wise.
Got 12:52.
Okay, so also kind of as part of this estate planning, but in particular, the work that you guys do, I think it's really important that you know the different forms of real property ownership in Michigan. These are the 4 kinds. Sure, you probably heard of all of those. So tenants in common, that is the default type of ownership. So if myself and Darwin decide we're going to buy a piece of property and it says Wanda and Darwin, our addresses, legal description, notary at the bottom, that's all it says. Darwin and I own that as tenants in common. That's what it defaults to because we're not married. That makes sense? In the tenants in common ownership, I can take my ownership interest and pass it on to my family. Darwin can as well. It depends on what it says in the deed. If it doesn't say anything, it's half and half. If it says Wanda has 60% and Darwin has 40%, then that's how it's divided. Good. Joint tenants is a little bit tricky because it encompasses tenants in common and it has a survivorship right. So if you have a deed that says A, B, C, joint tenants, just those two words. If A passes away, that interest goes to B and C. It's a survivorship right. But on the flip side, let's say that A doesn't pass, but instead, I don't want to own this cottage with these two. They can go off and sell their 1/3 share if it doesn't say otherwise. And then a new owner comes in. So you can sever that joint tenancy. Good. Now you guys have probably all heard of the joint tenants with rights of survivorship. Joint tenants with full rights of survivorship. Again, this is the last one standing wins ownership. So everybody owns it together. I can't sell off my share. I have to have agreement of everyone. So generally, as you may be looking at these, but again, it depends, because when I'm counseling clients, we go through these, and it's important that people understand the type of tenancy they're getting or giving, because it can have definite consequences. So one quick example. I had a gentleman come to me, and the story was him, adult son, and mom and dad had a deed. A, B, and C, joint tenants with rights of survivorship. Beautiful. Dad passes away. Now, mom and son own it, right? Joint tenants. Somehow, somewhere, I don't know why, they decided mom and son drafted a new deed. So the new deed that gets drafted and recorded says mom and son. That's it. Is getting it? Yes, then mom passes. Oh, so now son is left with half ownership in a property and mother's estate owns the other half because they were tenants in common. So they came to me. We actually had to open probate to get letters of authority, to sign mom off. All of this was unnecessary. The initial deed with joint tenants with the rights of survivorship was perfect. Nothing had to be done. Son would have owned the property, but there was a lot of time and expense in messing with these deeds that didn't need to happen. So that's my soapbox on deeds. And the last piece is tenancy by the entirety. So married couples. I think the important thing for you guys to remember or know is if, say, there's a couple and they're in love and they're going to buy some property and they buy it and they can put a tenancy on it. They could put joint tenants or joint tenants with survivorship, right? But then later they get married. Yay, congratulations. If they want to own that property as tenancy by the entirety, they must execute a new deed. You must be married at the time the deed is drafted and recorded for you to have this benefit. And there is a bit of a benefit because this is one of those things where my husband and I own our home. We were married when it was purchased. Even if it doesn't say anything else, it just says Wanda and Bruce, we're married. We own it as tenancy by the entirety. So I always throw my husband under the bus. If he develops a gambling habit and we've got creditors knocking on our door, they're not going to take my house from underneath me. It's protected in that tenancy by the entirety. So there is a good reason to maybe want to own property under this type. Sense?
What happens if one of them is on the deed for the house? Let's say the husband's on the deed for the house, the wife is not, the husband dies.
Probate,
It goes to probate.
yep, it doesn't, as you guys know, with our property laws and with property ownership, it's within those four corners of that deed. So, like changing from tenants in common to tenancy by the entirety, there is no magic that happens outside of that deed. So it's the same. It doesn't matter if it says a husband or like, Jim, a married man, he just owns that property individually. The spouse doesn't automatically get their name on the deed.
So unless our clients are advised with an attorney to, to discuss the proper, ownership for them, the title company will probably put in tenants.
Yeah. You guys would know better what title companies generally do. Either they don't put anything, maybe they add to.
But they should, seek advice from.
Yeah, it's one of my soapbox issues, because it's simple enough to take a bit of time to understand the tenancy, because down the road, it can cost a lot of time and money if that deed doesn't have the right type of ownership that client wanted. So nearly out of time. Question?
Yeah. So if somebody bought the property like before marriage, then after marrying, whoever bought the property, he died, then property goes to husband.
So again, if two people buy property and they're not married,
Yeah.
depends on what it's going to say on the deed.
So
They'll
if
be,
one people buy it, one is the property is on one person.
right, so let's say the wife buys the property, her name is on the deed.
Yeah.
But they marry later,
Yeah, they made like that.
nothing changes with the ownership on the deed. If you want,
Suppose the wife died.
then it goes to probate, and the husband, if there's no will only get a share.
Oh.
Property, assets does not automatically go to your spouse when your spouse dies, doesn't go to the spouse. Try not to confuse that too much. So
Even if it's in a trust,
again, it depends, because there are things where you're talking about a beneficiary designation, joint ownership, or under a trust. Those are not probate assets, and they will go according to the way that they're titled. So if a beneficiary is listed on a bank account, on life insurance, on a 401k, beneficiary is listed on a house under a ladybird deed, it goes to that person. It's not probate.
So gang, just for the sake of time, I want Wanda to be able to wrap up what she's got as a presentation. And obviously you'll have the benefits of however long she's got.
So really in general, under my little umbrella, example, funding a trust, if you choosing to have a trust as part of your estate plan, believe me, not everybody needs one. A trust isn't necessarily better than a will. It depends on your personal situation, but you have to fund it. So your bank accounts, your 401k, your life insurance, your house, your personal property, we've touched on all those. Each of those types of assets comes under your trust umbrella in a little bit different way. We know that real property is going to come under that umbrella with a deed. We know that personal property is going to come under that with that affidavit. If you want your bank account titled to the trust, or if you want to list the trust as the beneficiary on your life insurance, there are a variety of ways that assets touch and coordinate with a trust. So, I think we gotta know that. I'm just gonna do a quick thing, because again, I'm not a tax attorney. I don't do tax planning, but in Michigan, we don't have any inheritance, estate, or gift tax. But there is those taxes on the federal level. So anybody in here individually who has more than $13.99 million in assets, raise your hand. Nope, me neither. That is where we are right now with this federal tax. So unless you as an individual have more than 13.9 million in assets, none of this is a concern. But keep in mind, it may become a concern next year. Because if Congress doesn't extend that high exemption for gift in estate tax, we're going to fall back to basically 5 million adjusted for inflation. People are saying maybe like 6 million. So again, if you have more than 6 million in assets individually, you need to worry about some of these taxes. If you don't, I don't, then it's not an issue. All right.
Thank you.
Ta-da! So the estate's email is monitored by myself and the two assistants, Tyler and Amanda, that I work with. And I'm happy to answer, any more.
Can you give them the email again?
Yep, it's
on there.
Oh, it's on here.
on the
You're right.
card for those folks, but the ones
Yeah.
in virtual land.
All right, right up there at the top. They've got it.
I
So
didn't
right
want,
up here at the top, guys,
like,
I
Nan and
gotta
Nan,
do
we
this.
have-
She's got it right here. So if you got any questions, estates@linnellfirm.com.
Yeah.
So that's right there. So gang, sorry, I gotta do this. Literally, I'm slouching. Sorry, Wanda. I'm taller than her. Anyway, guys, a little bit over, but great job. Everybody give her a hand and you guys give her a silent one from out there. If you've got anything, obviously you can send it to estates@Linnell Firm and Associates there. And obviously, if you have anything, the ladies got the knowledge, send it to them, look to them, and we'll run it from there. Let's see, I can see that Fenton, you had a group. Lapeer, you had a group. I think Richmond I saw on as a group. If you guys would, make sure that we get your name, your license number, and email addresses. You can send those to me and I will get that to Terry so that she can give you the 1 hour of legal credit. So make sure that you get that if you haven't already put it in to the chat session. Other than that, guys, that brings up the end of another deep dive. We'll see you next week. We're probably going to be talking about, what I've always called this month in real estate. Or maybe it's going to be these weeks, because it's been a long time since we've had a general open discussion about what's been going on in real estate. One of the biggies we'll talk about, how do we hold an open house when I'm not the one who's designated? And we'll talk about that and whatever else may come up. And we'll run from there. See you next Tuesday.